Now, what is the case flow that leads to the issuance of a warrant of arrest? Let me give you an example. Let us suppose X kills Y and X then goes into hiding, meaning to say, after X committed the crime, he escaped to avoid being arrested. So much so that after about a month, it was only at that time that the police was able to gather a witness and file a complaint for murder against X in the fiscal's office. Then the fiscal, when the complaint was received by him, would have to conduct a preliminary investigation of the case, considering that it is a complaint for murder. Although there are other criminal complaints or there are cases where preliminary investigation is no longer required. But for purposes of this example, since the example is about murder, the prosecutor is enjoined to conduct a preliminary investigation. And a preliminary investigation is a proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. So, in a preliminary investigation, the prosecutor or the fiscal, after the filing of the complaint, in this example, will have to issue a subpoena addressed to the respondent or to the would-be accused, directing him to submit his counter affidavit within 10 days from his receipt of the subpoena together with the copy of the complaint filed by the police. And whether or not he submits his counter affidavit, the prosecutor will have to issue a resolution within 2 months from the time the case or the complaint was filed before his office. And his resolution would either dismiss the complaint filed by the police or recommend the filing of an information in court. Now, the word information is the name for the criminal case, which will be filed by the prosecutor in court, the court that has jurisdiction over the offense charged. So, when you say jurisdiction, it is the power and authority of a court to hear and decide a case. And in the case of murder, it is the regional trial court that has jurisdiction over the offense charged. So, when the information reaches the court, the judge would then have to evaluate the information, the resolution of the fiscal, as well as the evidence attached to the information. He must personally evaluate whether or not there is probable cause to issue a warrant of arrest. And if he finds probable cause to issue a warrant of arrest, then he will have to issue a warrant of arrest. If he doesn't find probable cause, at that point in time, the judge may dismiss the case, even without going to trial first. That is so provided in the rules. But let us stick with the case flow. So, to repeat, here, X kills Y, X then goes into hiding, meaning to say, the accused was not, X was not immediately arrested. It was only after about a month that the police was able to gather evidence. That's why it filed a case in the fiscal's office. The fiscal found probable cause to charge X with murder. He accordingly files the criminal case in court, and the court, after evaluating the evidence, issues a warrant of arrest. So, this is how a criminal case flows, leading to the issuance of a warrant of arrest by the court.